Hello. Avinash Puri, Dr. Anjum.
Yes, sir.
Sahu.
Yes, sir. Yes, sir. We are there.
Yes. Welcome. Yes, please ask the question. क्या हुआ? आवाज नहीं आ रही. Who wanted the question? To ask the question?
Please firstly ask the question, then we will start session. If there is any question legitimate at all, so you may ask to the professor, please. Unmute yourself and ask the question directly. Don't message in chat box. Ask the question directly, please. It's my humble request on behalf of professor, please ask the question. If there is no question, then we will start session.
And particularly, I request all of you to ask the question from recent law which has been enacted by the Parliament, that is Waqf Amendment 2025. Because some of the major provisions have been amended by the government, and they were also challenged before the Supreme Court. And Supreme Court has also put on hold some of the provisions of the new law which has been enacted by the Parliament. And therefore, anybody who wants to any sort of the clarification from that very act which has been enacted by the Parliament and reviewed by the Supreme Court. So I think you will be fully legitimate to ask the question from that very area. Otherwise, most of the areas have been covered already by me. This is an recent development that has taken place today. It is in the newspaper. So what will be the repercussion of all these amendments or new law which has been enacted by the Parliament? What are the apprehension of the people of the Muslim community? Therefore, they are agitating, they are opposing. Some people are also not in agreement. But some of the people, they are in agreement with the changes that has been made by the Parliament by means of this new law. So what is the reaction of you as a student of the law, student of this course? Am I audible to all of you? Hello?
Yes, sir. Yes, sir.
Am I audible? So
Yes.
any question from definition to section 9, section 14 of the new law? So any clarification from your side from the area of the Waqf Act 2025, which is Anjum, Dr. Anjum. What is your question?
Is recognized under the state act and Muslim male and female guidelines for total of provisions.
एक मिनट, चश्मा कहाँ गया है?
Please, Mr. Anup, ask the question directly to the professor, please, ma'am. Please, Dr. Anjum, ask the question directly, please.
अंजुम, अच्छा ला, क्या क्वेश्चन?
If the marriage is registered under any state act, then Muslim male can take divorce through triple talaq provisions.
Responding to this question, I would like to clarify that Uh, so far as the triple divorce is concerned, now triple divorce wide Muslim Women Protection of Rights on Marriage Act 2019 is made illegal and void by virtue of Section 2 of the said Act. Meaning thereby that in view of Section 2 of the Muslim Women Protection of Rights on Marriage Act 2019, triple divorce is illegal and void, and therefore no marriage can be put to end by means of divorce through triple divorce. It must be clear because it is illegal now at present, and now not only illegal but it is also void. Therefore, triple divorce is no more mode of dissolution of Muslim as it was recognized before this act, and therefore no marriage can be dissolved, no relationship created by means of the marriage can be put to end by means of triple divorce in view of Section 2 of Muslim Women Protection of Rights on Marriage Act 2019. Anjum, I think I have addressed your question.
लेकिन हसन तलाक के फॉर्म में तो सकता है
Yes, now these are Talaq-e Hasan, Talaq-e Ahsan, and Talaq-e Hasan. These are the two formula of the divorce recognized under Muslim law at present. And if the parties are not pulling on well and they are interested in separation, then parties can separate from each other by means of the divorce in the exercise of the either Hasan formula of the divorce or Hasan formula of the divorce. Hasan formula of the Hasan formula of the divorce is well explained. Hasan formula of the divorce is also well explained. Therefore, by means of the Hasan formula or by means of the Hasan formula, one can dissolve his marriage by pronouncing the Hasan formula of the divorce or Hasan formula of the divorce, because after this law, only the recognized mode of the dissolution of Muslim marriage are either Hasan formula of the divorce or Hasan formula of the divorce. I hope that what is Hasan formula of the divorce, what is the Hasan formula of the divorce, all of you are well aware about all these. Any more question? Abhishek, Avinash Pujari, Vikram Singh, Dr. Anjum. Any more question?
No, sir.
No. So I think I suggest all of you to download the new law, that is Waqf Act 2025, and you compare from the old one what new provision has been inserted in the new act, what major changes has been made in the new act, and what are going to be the impact of this law on the working of the Waqf in reality. So this is my suggestion, because definition of the Waqf has been changed, and the major change in the definition of the Waqf is that now only a Muslim who is following the religion of the Islam for last 5 years, meaning thereby only a practical Muslim is allowed to dedicate his property as a Waqf. Earlier, Muslim or non-Muslim both were allowed to dedicate his or her property as a Waqf, but now the change has been made in the definition clause. Section 3 subclause R has been amended, and now it has been made clear that only a Muslim who is practicing the religion of the Islam for last 5 years is allowed to dedicate his property as a waqf, and therefore no non-Muslim is allowed to dedicate his property as a waqf. Even if it is dedicated, it will not be recognized as waqf within the meaning of section 3 subclass R of the Waqf Act as amended in 2025. This is one of the major changes that has taken place by virtue of the new act. So you must be clear that and therefore one more thing I would like to clarify that a convert Muslim is not allowed to dedicate his property for next 5 years from the date of his conversion. Meaning thereby that if X was a non-Muslim, he converted to the religion of the Islam on 1/1/2025, say for example, and he wants to dedicate his some property as a waqf on 1/1/2026, he cannot, because rule is lies that a Muslim, a person, a owner who is a Muslim for last 5 years from the date of the dedication, only he or she is allowed to dedicate his property. And therefore, if one is convert, he has converted to the religion of the Islam from other religion, so he cannot dedicate his property for next 5 years as a waqf. On the completion of the 5 years, so this is the rider. This is the rider on the power of dedication as property, as some property as a waqf by anyone. Earlier there was no such rider. There was no such restriction. Any person, and any person means the Muslim or non-Muslim, both were equally allowed to dedicate their properties as waqf within the meaning of section 3 subclass R. But this change has been made, and now only a Muslim who only that very person who is a Muslim for last 5 years from the date of the dedication, only he or she is allowed to dedicate his property. If someone has converted to the religion of the Islam, so then from the date of the conversion for next 5 years, he will have to wait if he or she is interested to dedicate his property as a waqf. This is one of the major change that has been made by this new act, and there is objection. There is objection by some Muslim on this point, that since under the Muslim law, both Hindu and Muslim both are equally allowed to dedicate their property as waqf, because the objective of the waqf is to provide the economic or financial help to the people, to the poor people, regardless of their religion, and therefore this is a sort of the encroachment in the field of this law of the waqf. This is one of the apprehension. This is one of the objection which is being raised by the some of the Muslims. That is valid or invalid. There is a difference of the opinion on this point. But those who are raising the objection, their argument is that in the Islamic jurisprudence, there is no such prohibition, and now it has been prohibited by means of the new amendment. Therefore, this is a sort of the encroachment upon the Muslim personal law, and encroachment upon the Muslim personal law means it is in violation of Article 25 and 26, Article 30 of the Constitution, because Muslim have been given the right to establish a right to create the endowment, religious endowment, by dedicating their properties. And a Muslim law allows both the Hindus and Muslim both equally to dedicate their property for the welfare of the poor people of the society, and therefore preventing the non-Muslim from dedicating their property as a waqf is a sort of the encroachment upon the Muslim personal law, in fact. So this is one of the gray area for discussion, and of course discussion is going on not only in the academic circle, but still this discussion is going on at the bench and bar, and there is a possibility of further changes because Supreme Court taking the note of the objection raised by Muslim petitioners has put some of the provisions of new act on hold. They have state, Supreme Court has state, and therefore from the side of the government, from other side also there is a reaction that putting on hold Section 9 and some other provisions of the new act is a sort of the judicial overstepping. And this should not have happened. Even there are some political statement. They are also being made subject of criticism. So debate is going on all these provisions. The next important change which has been made, that is work by user has been deleted from the definition clause of the old act, that is work by 1995. In work by 1995, where definition section 3 subclause R of the work act 1995 defines what is the work, and also includes the work by user as a work. Now the government has deleted this work by user, and after passing of this act, in fact, work by user was no more valid work form within the definition of the section 3 subclause R. Taking into account the wider ramification of this amendment, this provision was challenged before the Supreme Court, and now the Supreme Court has prevented the government from taking any further step for making any notification regarding the work by user, and therefore the provision has this and government has been prevented not to make any notification or declaring the work by user as non-work. This type of the things are going on. So this is because the argument before the Supreme Court was that in past a huge number of the work properties were dedicated as work without any documentary proof. There was no proper documentation creating the work, and most of the work they were recognized as work by user because they were being used as work property for a longer period of the time, and therefore right now deleting them from the definition class will have a wider ramification, means huge work properties will go out of the purview of the work board, etc., and therefore it will cause a huge financial loss to the work properties, and therefore it was challenged, and taking the wider ramification of deletion of the work by user from the definition class, the Supreme Court has also put on hold this provision or this part of the amended law. Next is that there is a work council has been created by means of new act, and in the composition of the work council, even non-Muslim are also allowed to be the member of the work council. This was also a gray area of the objection. Objection was raised, even matter was pleaded before the Supreme Court. As Supreme Court in principle has agreed that making the non-Muslims as a member of the work board or work council may have adverse wider implication on the work properties or management of the work properties, and therefore Supreme Court has agreed with the argument raised by the Muslim organizations, Muslim stakeholders, And this provision has also been put on hold, has been stated by the Supreme Court that Section 9 and Section 14 both have been put on hold. They will not be in operation until the further order of the Supreme Court, that is till 5th May. This certain provisions of this act has been put on hold. So I think this is also a point to be noted. Mm, for those who are interested in this area. Further, the court will afford the opportunity to hear the parties on these points, will be allowed to argue their cases in detail before the Supreme Court, and final decision will be given the Supreme Court after affording the opportunity of being heard to both the parties, that is to the petitioner as well as the respondent, particularly the government. And thereafter, the final decision will come, and whatever final decision will come from the Supreme Court, that will be law of the land. I think and everybody will welcome that very decision. So, definition class, work by user, and the membership of the work council as well as the work board. They have been. And earlier, and one more thing, that in case of the dispute over a property, if the property is in dispute, then it can be acquired by directly by the taken over by the district collector. So this is also one of the area of the objection. Now the survey will be what properties are work properties, what are not work properties. Survey will be conducted by the district collector through its agencies. So this area has also been objected because earlier it was within the jurisdiction of the work board. So, ladies and gentlemen, these are the major areas of the concern which has been raised before the Supreme Court by the Muslim communities through the writ petition. Matter has been partially heard by the Supreme Court, and partial decision has been given, staying some of the major provisions, operating provisions of the new act, that is Work Management Act 2025. So my humble submission and suggestion is that all of you go through the new act and compare it with the old act, and what changes has been made by the government through the new act. What are the lacunas, what are the merits and demerits of these amended provisions. You reflect upon through your writing, and I hope that that will make a point clear to you as well as to the readers to whom the publication will be addressed. So I think this. Any more question from anyone?
Sir, is this act is in supersession of earlier act?
Yes. Now a complete new act with new nomenclature has been enacted by the government. Now earlier the nomenclature was the WACF 1995. Now the nomenclature of the WACF has been drastically changed, and therefore it is a complete new act. But of course, most of the provisions of the old act has been borrowed and put as it is even in the new act. But some of the new provisions has also been inserted too in the new act, and therefore this will be called as totally new act, not amended in 2025. The WACF Act 2019-95 as amended, only if certain amendment could have been made, and nomenclature could not have been changed, then it could have been called as the WACF Act 1995 as amended in 2025. But now the nomenclature title of the act is entirely different. What is the new title of the act? Are you aware about it? New title of the act, the Work Management. Yeah, what is this? Let's just talk.
Unified.
The unified work management. This is the nomenclature. The unified work management, empowerment, efficiency and development Act 2025. And in short, this act is known as Umeed, UMEED, Umeed Act 2025. Now it has been passed by the parliament, challenged before the Supreme Court, and therefore it is complete new act, which may be called as UMID, Unified Management, Empowerment, Efficiency and Development Act 2025. So, on the face of the record, it may in spirit it may be one and same, but on the face of the record, it is entirely a different one.
Sir, was there any, what is the rationality, need, compulsion to bring about new enactment?
In fact, according to the argument of the government in parliament, government has collected the data from across the country of the work properties. And according to the information available to the government, according to the information collected by the government regarding the work properties, most of the work properties are not properly managed, used, and applied for the purpose or purposes the properties were dedicated as work. And according to the argument of the government, the income generated by the work properties was misused by the mutawallis for their personal purposes. They were being spent on the purposes entirely different from the purposes indicated by the Waqif in his Waqfnama. And most of the properties, they were being converted into the personal use by the mutawallis as well as the Waqf board of the state concerned. And therefore, the government argument is that in order to enhance income of the work properties, in order to make the better management of the work properties, in order to enhance the potential of properties, now these amendments had become indispensable, inevitable, necessary, and therefore the government has enacted this law in the larger interest of the work properties. And the larger interest of the work properties means in the interest of the poor Muslim of the country, because so far as the basic object of every work is to provide the financial help to the downtrodden, underprivileged, poor people, orphans, widows, etc., etc.
Agreed, sir.
Now, the
Agreed. Agreed.
argument of the government was that purpose for which the properties are dedicated as work is not being fulfilled, and therefore now the need of the hour is that some robust law should be enacted to maintain the basic character of the work property dedicated as work, as well as proper documentation should also be made so that the work properties could be properly identified and its object could also be identified in order to fulfill it in the future out of the income generated by the work properties.
Agreed,
So
sir.
these are the
Agreed,
yes.
sir. But are these new provisions have come from the Muslim scholars? Were they taken into confidence? They were consulted?
Now, as per record submitted by the government before the parliament, a committee was constituted consisting of people from cross section of the society. Within a time frame, suggestions, objections, improvement were invited. They were collected, examined, considered, and then final decision was taken regarding the enactment of law. So the government is saying that after wider consultation, from the stakeholders, law has been enacted. It has not been enacted in isolation. Muslim scholars, advocates, politicians, and some other people, various Muslim organizations, religious houses, all they were taken, they were invited to come forward with their objection, with their suggestion, with their improvement, and people came, participated, submitted all these things. And after taking into consideration this wider consultation, this law has been enacted, and therefore, argument of the government before the parliament was that law has not been enacted in isolation, whereas opposition and people are saying that that law has been enacted arbitrarily by the government. Whatever suggestions, objections were given by the stakeholders, Muslim communities, schools, colleges, madrasas, people from school, colleges, madrasas, and the public domain, that has not been given the due consideration by the committee, and therefore law has been enacted arbitrarily, suiting to their own interests, and in this way government is trying to usurp over the properties, work properties. The government, this kind of the apprehension is lingering on in the mind of the Muslim communities, that after passing of this act, uh, uh, government will try to snatch the work property, whereas this may not be correct, 100% may not be correct. And therefore, you may be well aware that on the basis of these apprehensions, the law was challenged before the Supreme Court. And recently, on 17th of this March, Supreme Court has also given the decision. A partial decision has been given. Some of the provision has been put on hold. State further order. A final decision will take place after being a peace. So whatever decision will come thereafter, it will become the final, because still the act is judicially disputed.
The fact that on the very face of it, Supreme Court stated that how non-Muslims can be nominated on the Waqf Council. The same thing might not have been agreed to by the Muslim scholars when it was in a consultation phase. Still, government went ahead.
Uh, but their argument is entirely different, and are a very sound footing. They are saying that in Waqf Board and Waqf Council, henceforth, non-Muslim will also be the member of the Waqf Board as well as the Waqf Council of the state concerned. But their argument basically is that this is a discriminatory provision, because in religious endowment created by the Hindus, Muslim is not allowed to be the member. So why the non-Muslim should be allowed to be the member of the Waqf Board? So this is therefore it has been challenged on the basis of Article 14 of the Constitution. Moreover, they are having apprehension that nominating the non-Muslim parliamentarians or other people in the Waqf Council, Waqf Board, they will try to influence management efficiency of the Waqf properties, and therefore it may not be in the larger interest of the Muslims in future, and therefore they are before the Supreme Court on. And Supreme Court to some extent has agreed that this is discriminatory on the face of the record, because in similar institutions run by the non-Muslims, Muslims are not allowed to be the member. So why the non-Muslims should be in the Waqf Board or in the Waqf Council? This is a point of legal concern, and prima facie, the Supreme Court is in agreement with the objection raised by the Muslim communities, and has put some of the provisions on hold from operation.
The very example that inclusion of non-Muslims should have been fought tooth and nail by the Muslim scholars and the authorities and the organizations or community people.
No, it was opposed tooth and nail by those who were in parliament while the law was in process of final enactment. But as all of you may be well aware that every law in parliament is passed by majority. So in majority, the government in power, in majority, the government was in parliament, and therefore law has been passed by uh, in favor. The total number of the votes were 238 perhaps, and meaning thereby that by short of the 35 votes, Allah has been passed. So by majority, because majority, those who proposed the bill, they were in majority in parliament in the House of the People, and therefore law has been passed. Whereas some of the opposition, all the opposition, they were unitedly against the passing of this act on various grounds. Heated discussion took place in the parliament, in the House of the People, as well as in the Rajya Sabha. And after heated discussion and debate, 230? 88 in favor. 88, no, 288. 288 votes were in favor and 232 were against. So I think by a thin majority, law was enacted by the parliament.
If there is any question, may you put, please.
Thank you, sir.
Right. Thank you.
Tomorrow will there be any session?
Yes, one more session and one more session tomorrow at the same time, I think.
Thank you. Thank you.
Okay. So you frame the question, then you come on. Come on. In the meantime, you can frame the question on any subject, on any topic. You are free to ask the question from any topic. Okay. This is very interesting area, I think, in the near future. It will have a lot of the scope for in practice. Therefore, my humble suggestion is that you go through this law, that is this new act, which has been made by the parliament in the name of Work Management Efficiency Act 2025. You come out with the good point as well as the point which may not be acceptable to you or anyone. You can go through the newspaper also, because every day the newspapers are publishing something on the law which has been enacted by the parliament. So I think it will uh, uh, enhance your information and will be fruitful for your knowledge in near future. So with this again, I'm thankful to all of you for joining this session. Though it is online, had we been face to face, it would have been more uh, beneficial. Anyhow, we are in the age of internet and social media. So on social media platform, we can also exchange our ideas, our views, our points in the form of question, answer, objection, suggestion, explanation. So with this, I once again thank and close this.
Thank you very much on behalf of Professor Mohammad Wasim Ali as an official TA of concluding this session. Thank you very much.